What's up everybody, welcome to Money Management channel. My name is Andrei and today I'm gonna be doing an update on MMTLP and FINRA saga.
I got the cash in the bag, stadium packed, born a rock star in this life, gonna live it up.
And in today's video I will show you the answer of Roza Tawil to FINRA that was made just yesterday, and this document officially calls First Memorandum in support of plaintiff's Rule 59E motion for reconsideration of order. So let's jump straight into it. For those of you who don't know, Roza Tawil made, let me show you right here, made a plaintiff motion for preliminary injunctive relief, and basically it is a lawsuit against FINRA. And FINRA made its response on January the 6th, and right now Roza Tawil filed another document. As you can see, it was filed on January 11th. And let me quote you this paragraph first of all. Defendant filed its memorandum in opposition of plaintiff's temporary restraining order citing 1. Absolute immunity, 2. Alleging no imminent harm, 3. Lack of an emergency, 4. That plaintiff failed to demonstrate a ruling in her favor would serve public interest, 5. That the Sherman Act was superseded by the Exchange Act, 6. And that there would be no remedy by ruling in plaintiff's favor. And let me start with the summary. Right here in this document, by the way, I will put the link on this document in the description below, and you can read it by yourself. Right here in the summary, you can read all the details about the situation around MMTLP and its spin-off. Here I want to pay attention on this data. Because of the discrepancy for about at least 35 million shares in between the official number of NextBridge hydrocarbon shares and the potential number of shares on the market that was on the halting date on December the 9th, we can see this. Shareholder, including plaintiff, face loss by either 1. Forcing NextBridge Hydrocarbons to issue an additional 100 million shares to cover the unreconciled difference, thereby diluting shareholders' interest, including plaintiff. Or 2. A total loss by a failure to receive shares of NextBridge Hydrocarbons and shareholders being prevented from selling MMTLP shares for fair market value to obligors holding short positions due to the halt disrupting all trading while short positions were outstanding. And definitely both of these options are not good for retail community that holds holded MMTLP shares, but it is extremely profitable for the market makers and for the naked short sellers. Let me quote you further. Roza Tawil proposed to reinstate the MMTLP trading, and by reinstating MMTLP and removing CUSIP numbers that have no value, plaintiff would be restored until a reconciliation can occur. Plaintiff requests the restoration of MMTLP until an accounting of all actual, short sale, borrowed, loaned, and any and all forms of Series A preferred dividend MMTLP proves no shares in excess of the issued 165,523,363 shares are outstanding. This will prevent further harm to plaintiff at little to no burden on the defendant. So, and I completely agree with this statement. And because of this, plaintiff requests first, an accounting of all actual short sale, borrowed, loaned, and all forms of Series A preferred dividend stock as was ordered in Myriad Securities Incorporated versus Financial Industry Regulator Authority Incorporated. The reassurance of MMTLP to preserve plaintiff's investment. And 3. A delay in the issuance of NextBridge Hydrocarbons until a full reconciliation has occurred and shares outstanding is in balance with shared issues. This is a very important point, and in my opinion it is a crucial point of the entire saga. So, right here you can read the arguments, and I want to pay your attention on just several ones, the most important in my opinion. So right here you can see that the defendant does not have absolute immunity in suits for equitable relief. And as a self-regulating organization, FINRA enjoys absolute immunity from private suits seeking damages for actions within the scope of FINRA's regulatory authority. But in the suits for equitable relief, it does not have absolute immunity. And it is a very important point. This means we can sue FINRA for its harmful activity and for potentially its fraudulent actions. So, number 4. Public interest in ensuring that parties acting in concern do not dilute private company stock. And here is another important part, because NextBridge Hydrocarbons is a private company and no one can force any private company to dilute its existing shareholders by issuing more shares. And with the proposal to quote-unquote print more shares to cover the discrepancy in between synthetic shares and the real number of shares of 165.5 million, the existing shareholders will be in a loss because of this dilution. And nobody can do it because it is a private company and no one can force any private company to dilute its shareholders. Another one. Regulatory agencies are subject to antitrust laws and those not suppressed by the Exchange Act. And this means FINRA is a subject to this antitrust law. And this means we still can have all the interaction in between the retail community and FINRA because of this law. And another point that in my opinion is very important. Number 7. FINRA erroneously claims the extraordinary event justifying the halt is uncertainty in the settlement and clearing process. And here is a perfect explanation in my opinion, and let me quote you this entirely. Torchlight Energy Resources entered into a merger with Metamaterials, creating the Series A preferred share known as MMTLP. The record date to receive a 1-to-1 exchange of symbol MMTLP and 2-to-1 exchange of symbol MMAT was June 24th, 2021. Any trades made after June 24th would not qualify for MMTLP oil and gas asset preferred shares. On June 25th, trading on TRCH continued until the close of business. As of June 28th, the settlement and clearing process was complete. As of June 28, 2021, trading began under symbol MMTLP with no extraordinary events. So, the merger of Torchlight Energy and Metamaterials is arguably a significantly more complex settlement process to settle. The exchanges occur for different rates and different rankings of stock, preferred stock and common stock. However, trading continued past the record date and the settlement cleared without significant uncertainty, and the defendant did not interfere or halt trading. And I have to say that it is a perfect explanation that FINRA did some unusual things because of this halt, and it wasn't the U3 code, unexpected circumstances, that should be the reason of the halt of trading MMTLP stock. And definitely it is another evidence that FINRA does something wrong with minor companies like Metamaterials and NextBridge Hydrocarbons. So, for the conclusion, let me quote you this. For the foregoing reasons, plaintiff respectfully requests this court grant the plaintiff's motion for reconsideration to vacate its prior decision, thereby reconsidering the motions for preliminary injunction and temporary restraining order before the court. And I have to say that in general, these documents are quite difficult to understand, and everything that we can do is just follow this information and wait for the judge's decision. And as long as we don't have this decision, all you have to do is to file this form if you haven't filed yet. And this form allows to know what brokerages have what number of shares of MMTLP in order to find out which of them potentially was involved in the fraudulent activity of FINRA and of other authorities. That's why it is really important. And if you want to know the entire situation, just read this document made by Smokey. And right now it has 39 pages in it. And you can know the latest updates directly related to this saga. So I will continue to do an updates on this topic, and if you like my video, please hit the like button and subscribe to my channel with notification bell, and see you guys and girls next time. Bye.
I got the cash in the bag, stadium